SJC-11852, Commonwealth v. Raheem B. Garrett.
Good morning, Mr. Chief Justice and Associate Justice of the Supreme Judicial Court. I'm representing Mr. Garrett here today. In this appeal, Mr. Garrett is asking the court to enter judgment of acquittal on him on the 3 indictments of which he was convicted. We do this because the Commonwealth proved in its case of Chief that there was not a firearm.
I'm sorry, do you say an acquittal or do you say to reduce the conviction to unarmed robbery?
No, I would respectfully submit acquittal.
And why would you be entitled to acquittal when the jury found that he committed a robbery?
Because the indictment states handgun, and the indictment also states armed robbery, and that's what the Commonwealth alleged throughout its trial and in the indictment, and that's what it was submitted to. There was no instruction on a lesser included offense. It was solely tried on the basis of the defendant robbed these stores and persons with a handgun, a firearm, and that proof failed.
But your sole basis is on that element, the handgun element. Well, not as to the other elements.
Well, it is based on that element. Certainly is what it revolves around, but it also revolves around ineffective assistance of counsel as well, and that there was no pretrial motions. There's also an issue of
Of course, you need to be a little bit, I mean, there's certain irony there in that if there had been a pretrial motion to dismiss, the Commonwealth arguably could have reframed the indictment and alleged dangerous weapon, and then you'd be...
That could be the case, but it is part of the argument.
Are you arguing that the BB gun, looking the way that it did, but anyway, the BB gun was not a dangerous weapon?
No, the BB gun under previous law was a dangerous weapon, as it was used as a dangerous weapon.
So if you have the proof, I'm just following up on Chief Justice Gantz's question. If you've got the jury finding that there was all the elements of armed robbery, plus, all the elements of armed robbery with a dangerous weapon. Why?
Because that was never brought before the jury or even in the instructions. This is an indictment under a very specific provision. The case must be charged as proved as charged. That did not happen here. I think the court cannot simply say, well, they didn't prove firearms, so we're just going to go under a different provision of the statute. That was different legislative, different intent, and sentencing. I don't think that's fair to Mr. Garrett, and it's overly generous to the Commonwealth.
Why isn't it fair to him? I'm just a little confused. He's charged with an aggravated form of armed robbery, that is armed robbery with a firearm versus just any old other dangerous weapon. It's clear that he was convicted of armed robbery. You may win on the failure to convict on the aggravated form, but why isn't that just logical?
Well, because under precedent of the Supreme Judicial Court, that he was charged under only one theory, one crime, one provision of the law, and only one provision of the law to say, well, the Commonwealth didn't meet its proof on that.
Well, I mean, you can be charged with aggravated rape and still be convicted of rape.
Well, I would suggest that this is different because
This isn't an aggravated form of armed robbery?
No, I wouldn't say so. He is charged with firearm. He was specific, and that is different than dangerous weapon. The legislature specifically put in a provision about firearm and made a minimum mandatory sentence and changed the legislation throughout the criminal code, so to speak, of saying firearms are different, and there's a reason to treat firearms as different and specific.
Well, isn't this just an enhancement idea here that, okay, you commit armed robbery, but if the Commonwealth proves that it was committed with a firearm, then you get an enhanced punishment, which is what the statute provides for. So how do you get a free pass on the armed robbery?
Well, I would respectfully submit that it's not a free pass. The Commonwealth charged a specific theory of the crime.
Well, they charged armed robbery, right? And they did say firearm, but if it wasn't a firearm, but something else, isn't that still armed robbery?
Well, armed robbery by itself, I would respectfully submit, is not the crime. I would suggest that that's a semantic handle that describes two different crimes, okay? And that if an indictment just came down and said the defendant committed armed robbery, that would not state a crime in the Commonwealth of Massachusetts. It has to be armed robbery by dangerous weapon or armed robbery by firearm. And that's the status of the statutory law.
Even if Chief Justice Gantz's question was, take out the armed part because of the confusion that you say, don't you still have unarmed robbery?
No,
Why?
because there was a specific charge.
Yeah, but isn't unarmed robbery a lesser included offense of armed robbery?
It depends on how I would say, not if it's specifically charged. If there's a specific theory charged, like it happened in this case, you simply can't go to the default position of robbery.
So under your theory, manslaughter is not a lesser included offense of murder.
Well, I can't say I specifically, I would say there's different elements.
Would you say if the Commonwealth had asked for, or you had asked for, I don't think this happened, but an instruction, if the Commonwealth had asked for an instruction on unarmed robbery because of some question whether the jury was going to find that element to be met, would they not have been entitled to it?
No, they would not have been entitled to that because there's no basis in the evidence for a lesser included offense instruction in this case, even under the generous interpretation of lesser included offenses that this court has used. The only weapon used was that weapon. There's no theory to say that it was fists only or this was a kind of a street mugging. I mean, that is the defendant is asking that go by this very specific record and the very specific jurisprudence of this court in terms of firearms.
Right, but
The Commonwealth made a choice.
Now you've thoroughly confused me, because if you say the crime is the commission of a robbery by use of a firearm, and then you say, well, a BB gun is not a firearm, wouldn't then, if you're going to make that argument, and if there was any debate about that, would the jury not be entitled to say, you're right, it's not a firearm, he's just guilty of unarmed robbery? Because he's not guilty of robbery with a firearm, he's guilty of robbery.
And the facts that were presented to the jury, there is no basis for a lesser included offense in that case.
Okay, let me also ask you, you said that this, I want to clarify, when you spoke of that the use of the BB gun could be the use by a dangerous weapon as used in this case, I assume you mean that the evidence would be sufficient to so find. I gather the jury was never instructed as to dangerous weapon, and therefore the jury never made a finding as to that.
The jury was instructed, erroneously instructed as to a dangerous weapon. But once again, if the indictment had
Was it
read...
instructed about dangerous weapon or about what a firearm was with the replica?
Well, yes, but my subsidiary argument is that instruction was inappropriate. The defendant was not charged with a dangerous weapon. It's different. I am asking the court to draw a distinction between the two based on the statutory provisions and based on the public policy division by the statute, provided by the statute in this case. If the defendant had been charged with armed robbery or armed robbery by means of or with a dangerous weapon, then it would be a different case. But the Commonwealth chose firearm and made that specific allegation, and it did not meet that specification as a matter of fact in law. Mr. Garrett cannot be convicted of the crime charged in the indictment based on this factual record. And I do renew my motion to have the court look at the item in charge. It's not a firearm. That's my opinion here. I
mean, this photo in here? This weapon, which certainly looks like a firearm to me.
well, it certainly does look like a firearm, but that doesn't mean it's a firearm.
No, I know.
it doesn't.
And by that, I assume you're adopting the definition of a firearm that would be used in terms of whether it may be possessed
Yes.
without an FID card or carried without a license to carry.
Yes, and the firearm is not defined in the criminal law mostly, especially under General Law 265-17. But where do you have to go for the definition?
It's 14021, right?
Yes, and that would be Commonwealth versus Rhodes, and that would be Commonwealth versus Fenton. I think that's where you have to go, and that's the only place you have to go. And when the court has interpreted those provisions, firearms very specific, and the tenor of the jurisprudence by this court is not a firearm. BB guns are not a firearm. Flare guns are not a firearm. Very multiple objects are not a firearm. So for this court to hold that it was a firearm.
Did Rhodes answer the question?
I'm sorry?
Did Rhodes answer the question as to whether or not a BB gun was a firearm? In fact?
I think it answered the question insofar as it says whether it's a firearm or not. It is not going to be treated, whether it could be considered a firearm, it's not going to be treated as a firearm. BB guns are not going to be treated as firearms under Rhodes. That's how I read Rhodes, and it should be interpreted as BB guns are BB guns, and that's why it comes under BB gun legislation, not firearm legislation. Now, that is the best law that's on the issue, and I would respectfully submit that if it meant BB gun, there's a 10J provision, and it says propulsion by any means, and that would maybe include the BB gun in this case. But so far it doesn't. It would be a departure from the court's jurisprudence to hold that this is a firearm, and I would specifically meaning the BB gun, and that could not be retroactive. That would be new law that is contrary to the precedent, the statutes, and it cannot be implied as this case.
That's assuming that Rhodes means what you say it means. I looked at the case, and it's not a decision on whether a BB gun is a firearm. It just says that the defendant in that case couldn't be charged because there was no prohibition on an adult having use of a BB gun. It didn't address the question of whether or not a BB gun is a firearm. That's an open question, right?
Yes, I clearly the court has to make a decision whether, and apparently it is an open question, especially under 17. But what is the best law on the issue? If there was going to be research done on the issue, which way does the law go? The law goes not a firearm.
Well, how does that help you?
Because
how does Rhodes help you?
Well, because Rhodes, insofar as Rhodes makes an indication whether a BB gun is a firearm or not, it indicates that a BB gun is not a firearm. It's different. It's not a killing weapon. It doesn't shoot a projectile by explosion, and that describes a BB gun in this case. And the court will see that this is a CO2 gun if the court chooses to look at it. There's no dispute that it's a BB gun.
It says, Rhodes says, although a BB gun, which does not propel a projectile by means of an explosion, would not ordinarily be considered a firearm, the term is a statutory word of art, which by proper definition could include such an instrument.
Well, it could include, but there's no statutory definition. That condition does not obtain.
Well, Sayers included it under 10J, right, in that
Well,
context?
yes, but 10J is different language. And
No, I agree, but I'm just saying,
well, it could, but that I think that would argue in favor of Mr. Garrett, that they specifically said BB guns in schools are going to be treated in this way by any means. That's 10J. That's not 10A or the other authority that I cited.
was there, am I correct, that there was no lesser included charge to this jury of unarmed robbery?
There was not a lesser included charge of unarmed robbery in this case. There's some ambiguity in the excessiveness of the jury instructions is that it says toy or replica or something. And that is not this case. It's not a toy. It's not a replica. It's an actual BB gun. And that is the Commonwealth's case in chief. His co-defendant presented essentially the Commonwealth's evidence in this case virtually in its entirety.
What was the defense in this case? Remind me.
Well, the defense in this case, to best as I understand it, was the Commonwealth's witnesses were not credible. So it would be a reasonable doubt defense.
So the defense didn't revolve around the BB gun. It
No.
revolved around whether he did it or
No,
not.
and that is part of my complaint, that there was no legal arguments by trial counsel. Trial counsel mounted a factual defense, but trial counsel also has to argue a legal defense. The appellate counsel cannot do anything about the trial, but trial counsel can do a lot about the appellate record. There was no legal defense on this issue here, and I would say that's ineffective assistance
But
of counsel.
beyond doubt, you would agree that the use of a replica or a BB gun in a robbery is an armed robbery.
Armed robbery, dangerous weapon, or possibly the new replica law, but which was not in effect in this case.
But
not
armed
a
robbery,
firearm.
dangerous weapon, it could be if it had been charged
Yes,
as such.
because that term has been very expansively defined in the case law and doesn't even require a weapon. It can be a finger or anything else, but not a firearm. So I'm asking for a not guilty.
Thank you.
Counsel, can I ask, where did this indictment form come from? Handgun? Is this a term of art? Robbery by handgun?
I'm not sure if I understand the question.
Well, why does the indictment have handgun as part of it as opposed to dangerous weapon?
Or firearm.
Firearm.
Well, I believe it's because the BB gun actually resembles a handgun.
But it isn't one.
Is it the argument, is the point, or was the point raised that by converting the BB gun through painting it so that it began more closely to look like a real handgun, it became a replica handgun? Is that the argument?
Well, our argument is that a BB gun, it is a BB gun, but our argument is a BB gun satisfies the definition of firearm under...
You're not arguing that the painting converted it into a mock or replica weapon. That's, even though that was the instruction. Who asked for that instruction?
Not too sure. I think the judge just gave it. I'm not too sure either side asked for it.
Okay.
But our argument is that a BB gun satisfies the definition of a firearm.
Okay, what definition are you applying?
Yeah.
Under 140, Section 121, which defines a firearm as a pistol, revolver, or other weapon of any description.
Well, if that
Okay,
was the
so,
case.
I'm sorry.
You
Well,
might-
I mean, I don't have an FID card. Are you,
Correct.
or a license to carry. You saying that and if I go and purchase a BB gun, are they going to ask me whether I have an FID card or a license to carry? Is that going to stop me from buying a BB gun?
No,
But it would stop me from buying a firearm.
that's correct. However, it's within the legislative's discretion to provide for different licensing requirements for different firearms. We're stuck with the definition from the legislative where a BB gun satisfies that definition. It says, or any weapon, or any other weapon, excuse me, or other weapon of any description. And here we have a BB gun is a weapon. And I should
From which a
should
shot
note,
or bullet can be discharged.
Ki-
Is this a
CO
shot or bullet that's capable of being discharged from this BB gun?
yes,
What is discharged and how?
CO2.
the BBs are what's
Is it
discharged,
CO2
and BBs are what are discharged from a BB gun, and
What is a BB?
well, it's a little.
I never had one as a girl.
I didn't grow up with, around
copper
firearms
sphere?
either.
I
But
thought
it's a
this
little,
was a CO2 cartridge or something like that. Is that?
no, the evidence at trial was that this was a BB gun.
Right, so it
That-
shoots BBs, but I want to know what BBs are. I mean, are they like little pieces of air that just pop and they open and can you kill a bird with a BB gun?
Well, you can
Yes.
you can
And kill a person.
You can kill a person with a BB gun, okay.
you can inflict serious injury. They have a warning that, wear goggles when discharging this item because,
So a BB is, you're saying it falls into the category, what is discharged is a shot. If
is
it's
a
not
BB
it's
shot because
not a bullet, it's a shot.
that's correct. In the statute that governs BB guns states that no person shall discharge a BB shot, pellet, or other weapon,
Don't you think if
or,
that,
or other.
to get to your result, we would have to overrule Rhodes, wouldn't we?
No, so Rhodes left it unanswered whether a BB gun qualifies as a firearm. And again, it's within the legislature's discretion to impose different licensing
Second
requirements.
question. We've got a criminal statute here.
Mm-hmm.
Doesn't define it. Doesn't the rule of lenity come into play? Something that isn't a firearm, are we going to really make it into a firearm for purposes of the enhancement portion of 265, Section 17?
Yes, because it falls within that definition that the legislative has provided. And I should note that further on in the definition of firearm, it says, provided, however, that the term firearm shall not include any weapon that is constructed in a shape that does not resemble a handgun. Here, the BB gun resembles a handgun.
But what was the legislative intent behind this new statute, the 1998 amendment? Wasn't it to specifically prevent the use of a gun that discharges projectiles by means of an explosion? Essentially a weapon of death. A BB gun's not that kind of a weapon, is it?
But the definition says, or other weapon of any description.
But my question is, what is the legislative intent?
I think the legislative intent is to have a requirement of an FID card or a license to carry if you have a shotgun, a rifle, a handgun, because that's capable of producing death, versus a BB gun where doesn't necessarily cause death, can cause serious injury. Possibly, Justice Botsford, I think he said it could
Well, I think
cause...
some of, I'm not saying this one can, I'm just saying I think some of them can, possibly.
Two birds.
So you can commit a robbery with a BB gun, and it qualifies as a firearm. You get enhanced punishment. You can commit a robbery with a bow and arrow, which can kill somebody, and that's simply a dangerous weapon.
Yes, that's correct, because it's not capable...
Or a knife.
Right, because they're not because they don't satisfy the rest of the definition. It's a weapon, but it's not capable of discharging a bullet or a shot, and it doesn't have a barrel length of less than 16 inches.
Can I ask you this? Let's assume for the minute that we don't agree with you, that this qualifies as a firearm, and therefore that the enhancement portion doesn't come into play. You argue, your last argument is, well, if all else fails, the defendant should be resentenced for unarmed robbery, correct? But you didn't ask for a lesser included instruction at trial, or the Commonwealth didn't, or nobody did, correct?
Correct.
So how do we get there?
Just under the case law, where and I cite to Commonwealth v. French, which is a 2012 case out of this court, where it says even though the judge didn't instruct on a lesser included, you can still have the conviction affirmed under the lesser included.
Well, it's clear from the record, or is it? Is it clear from the record that the jury necessarily convicted him of unarmed robbery.
It is clear because the victims, the store clerks felt threatened by the defendant's actions.
Did the store clerk testify to that effect?
Yes, all three of them, and this goes into my next argument, is that all three of them felt scared, and that's why they turned over the money. They believed that the BB gun was a real firearm. And if I may, I'm going to go into my next argument. If you don't find that it meets the definition of a firearm, it's Commonwealth's argument, so long as the victims objectively perceived it to be a real firearm, then the conviction can be affirmed.
But I guess that gets to my lenity question. We have an enhanced penalty, a mandatory minimum sentence, or minimum mandatory sentence, whichever way it is. Shouldn't we be looking at that very strictly so that what might be true of common law armed robbery, that is, if the victim perceives it as a dangerous weapon and acts in response to that, is one thing. But if you've got a statutory enhancement, wouldn't that be a different situation? So that it really matters whether it is a firearm or isn't a firearm?
I think that's a good point, but we're just asking to take the same factors from Tevlin. This court in Tevlin applied 3 factors to determine whether a dangerous weapon, a neutral object qualifies as a dangerous weapon. We're asking that you take those same 3.
Is Tevlin a statutory interpretation case?
No.
It's common law kind of thing.
What?
Common law?
I believe so, Your Honor, yes. I don't believe it was statutory construction.
Is armed robbery by means of a dangerous weapon a lesser included offense of armed robbery by means of a firearm?
That's a good question. Some of my colleagues believe it is. In the end, when you look at the case law dealing with lesser included, because the different elements, because they're 2 different elements, I don't believe they are.
Did the judge instruct that a BB gun is a dangerous weapon?
No. He did not.
As a matter of law?
No, he gave the firearm instruction from Chapter 140.
Correct.
And then he also gave a replica instruction, correct? That a replica of a firearm used to commit an assault, I'm not quite sure what he was getting at, but is sufficient if the victim reasonably believed it to be a weapon capable of inflicting serious injury. That sort of goes to armed robbery generally, right?
Correct, and that's what we base our objective belief argument off of.
I mean, it seems to me that if you have an armed robbery, someone using a replica, or someone using something that looked like the gun in this case, and the gun was never recovered, could you ever get a conviction for firearm? Armed robbery with firearm?
So if it
Gun was not recovered. You had 3 armed robberies here, gun was not recovered.
And it was a real firearm?
No. How do you know it was not recovered? It looked exactly like the item here. It's never recovered. You can get a conviction for armed robbery with a firearm, can you not?
Armed robbery by means of a firearm?
Right.
Correct.
There would be sufficient evidence if everyone testified, this is what it looked like, and I believed it was a firearm. That would be sufficient.
Yes.
All right? But once you have it, and let's assume it doesn't meet the definition of firearm, let's assume we conclude that a BB gun for purposes of this statute is not a firearm, doesn't that undercut that completely?
I don't believe so, because I think it's just more of a common sense argument that where you have 3 store clerks all saying, I believe this was a gun. One of the store clerks testified, I thought he was gonna, I was saying, I hope he doesn't shoot us.
And that would be armed robbery by means of a dangerous weapon. We're talking about armed robbery by means of a firearm, which has this enhanced piece.
Right, so certainly, at the very least, you could have armed robbery by means of a dangerous weapon. Under the current case law, you could have armed robbery by means of a
But you're
dangerous weapon.
saying you didn't charge that here and you don't
Right.
think it's a lesser included?
Correct.
Really? Okay.
Right. So, yeah, so basically, we're stuck with the conviction where it's armed robbery by means of a firearm. And if this court doesn't find that a BB gun meets the definition of a firearm, then we're just saying that because the victims objectively perceived it to be a real firearm, that should be sufficient to maintain the conviction. It's just, to me, it's a common sense argument. I was listening to the radio this morning coming in, and one of the radio reports was over the weekend at Revere Beach, an individual had a BB gun. He was out on his balcony, and the individuals on the sidewalk believed it was a rifle. That's why they called the police. And then they interviewed the Revere mayor, and he said that, I know our police get it confused all the time between, even that the police can't determine if it's a real firearm or if it's a BB gun. I just think it's a common sense argument.
They common sense, but the legislature would have permitted a life term if you had simply characterized it as a dangerous weapon. So the legislature obviously takes it very seriously that armed robbery by something that looks like a firearm but is not a firearm can get you a life sentence. It's not as if the legislature has not criminalized it.
Right, but
But you're seeking to call a dangerous weapon a firearm because it looks like a firearm, but it's not. Or you say it is.
But as long as the testimony from the victims is that it objectively appears to be a firearm, I believe that's sufficient.
So the same evidence would satisfy both a conviction under either theory, and depending on how the person was charged, he either get the enhanced or the regular potential life sentence, simply because the victim thought that the guy had a real gun.
Well, I think it's going to be, the prosecution has to be very careful on how they indict and charge these, type of cases where you have, and we provide the photographs, where you have a weapon that looks like a real handgun, then I believe that's sufficient.
All right.
Because everybody thinks it's a firearm. They don't think it's a BB gun when you're being held up.
Okay, thank you.
Thank you, counsel.
Okay, thank you.